The Honorable Mr. Mark Golding, Leader of the Opposition, the Honorable Marissa Dalrymple Filbert, State Minister in the Ministry of Justice and Constitutional Affairs, the Honorable Mr. Justice Brian Sykes, or Chief Justice, the Honorable Mrs. Justice Marva McDonald-Bishop, President of the Court of Appeal, and our distinguished lecturer today, the Honorable President of the Caribbean Court of Justice, Winston Anderson, and judges of the Caribbean Court of Justice, Justices Rajnath Lee, Justice Barrow, Justice Jamadar, Justice Ananawu, the Honorable Madam Justice Louise Blenman, Chief Justice of Belize, and you may notice they are with us virtually, judges of the Court of Appeal who are here almost in full court, Supreme Court judges, parish judges, judges from around the Caribbean, including the President's classmate, the Honorable Mr. Justice Patrick Wells, who sits in the High Court of Barbados, the Honorable Mr. Justice Patrick Brooks, former President of the Court of Appeal, who is online, and the Honorable Mr. Justice Seymour Panton, former President of the Court of Appeal, who is with us. I want to say, and sometimes letter writer to the newspaper, the Honorable Mrs. Justice Hilary Phillips, former Judge of the Court of Appeal, Mrs. Marlene Aldred, Solicitor General, Ms. Stacey Ann Brown, the Registrar of the Court of Appeal, Professor Marvin Reed, the Principal Director, Office of Research, Innovation and Partnership at the UA, or Dean Professor Shazida Ali, the Principal of the Norman Manley Law School, Dr. Christopher Malcolm, the Honorable B. St. Michael Hilton, KCOJ, Reverend Carl Johnson, President of the Baptist World Alliance and pastor of our lecturers' church, Filippo Baptist in Spanish Town. There are many other Filippo Baptist folks around, I suspect. Mr. Keith Bishop, also of the class of '94, to which the President belongs, and the husband of the President, and all family members and friends of the President. I also want to welcome, and I see several of them here today, all members of the class of 1994, graduating from the Faculty of Law, the University of the West Indies, which is the graduating class of the President, and welcome to our students, to our colleagues, to the profession, to you all. It's a real pleasure for the Faculty of Law to have you here for this distinguished lecture by the President of the Court of Appeal. The room is filled, President, not just with people, but strong feelings about you. Feelings of admiration, feelings of pride, feelings of deep respect. And certainly for the students who you'll see, they're primarily sitting to your left. Some are Norman Manley Law School students, many are students of the Faculty of Law. This is, for many, the first time they will meet you and see you in person, instead of reading your decisions from afar. This week, my students in family law looked at 4 of your decisions on the Property Rights of Spouses Act. And the students come in awe. They come with curiosity about judges whose interpretations become woven in the legal texts which they learn. I want to say, President, how important your presence here today is and the importance of your lecture. Few issues related to judging capture the public's attention more than sentencing. It is the preeminent site of disciplined and principled judicial decision-making, and it is also one of the more decipherable dimensions of judging for the public. Sentencing is also an area in which the Parliament is deeply interested and is one of the most legislated areas in recent times in criminal justice. Some of you will remember that 50 years ago this year, the Privy Council examined, as did President, your own court, the constitutionality of a fixed sentence, detention at hard labor during the Governor General's pleasure in the well-known Hines case. When Lord Diplock came across the road to the law school a few years later, he said the judiciary have a heavy responsibility as well as power to make the Constitution work and as trustees of the Constitution for the people. Your lecture today, President, is both timely and of the utmost importance. 50 years later, as we continue to talk about sentencing, you will remind us of the great responsibility and power of judges in sentences and the agility required to determine just sentences across a web of legal considerations, including constitutional guarantees and principles of sentencing. Although no one is in doubt, either online or here today, I can say we're all in the right place today and this evening. Can I invite you, Professor Shazida Ali, or Dean, to bring greetings and a message from the Vice Chancellor?
Thank you very much, Madam Chair, Professor Robinson. I'm sure you'll all agree that Professor Robinson did an excellent job of recognizing all the dignitaries present here in the room and online. So please permit me to say all protocols observed. And so I am tasked with the delightful honor of welcoming you all here to Mona Law to listen to the distinguished lecture to be delivered by the Honorable Mrs. Marva McDonald-Bishop, President of the Court of Appeal of Jamaica. And I am extremely delighted that you have chosen this special day in our calendar to deliver this lecture. And so I welcome you. I am also particularly honored that you accepted our invitation to deliver this lecture, since you are not only one of the region's leading jurists, but also one of this university's most eminent alumni. And the topic you have selected is, of course, as Professor Robinson mentioned, significant and intriguing. And particularly in a country like ours, which unfortunately has been plagued by high crime rates, the issue of crime and punishment remains paramount for all citizens. And so, for the judiciary, seeking to balance the objectives of punishment under the criminal law whilst protecting individual rights in a constitutional democracy, must certainly place a heavy burden on those who are charged with sentencing. And so I am looking forward to hearing your lecture. I know my colleagues and all the students present and everyone else here in this room are sitting and waiting with bated breath to hear what you have to say. And so I welcome you on behalf of my colleagues and students of Mona Law. But if you will permit me, as Professor Robinson mentioned, the Vice Chancellor, regrettably, was unable to be present here this afternoon, but he has asked me to share his greetings. So allow me a moment to deliver this message, which is written by Professor Sir Hilary Beckles, Vice Chancellor of the University. It is my distinct honor to extend warm greetings on behalf of the University of the West Indies as we gather for this distinguished lecture by the Honorable Mrs. Justice Marva McDonald-Bishop, OJ-CD. The Honorable President is an alumna of the UWI and is the first female president of the Court of Appeal. The topic of the lecture, Sentencing in a Modern Constitutional Democracy, invites a timely and necessary dialogue. In societies governed by constitutional principles, sentencing is not merely a procedural endpoint, it is a reflection of our values, our protections, and our aspirations for equity and reform. In an article in the Gleaner, dated December 7, 2020, Dr. Lloyd Barnett reminded us that It is not beyond our capacity to effect important improvements in our constitutional system. This call to action resonates deeply in the context of sentencing, where the law must continually evolve to meet the demands of fairness, proportionality, and human dignity. The Honorable President brings to this conversation a wealth of experience and insight. Her reflections will no doubt challenge us to consider how sentencing practices can uphold constitutional guarantees while responding to the realities of modern society. As Vice Chancellor, I am proud that our institution serves as a forum for such critical engagement where legal scholarship meets civic responsibility and where ideas shape the future of justice. On behalf of the university, I extend heartfelt thanks to the Honorable Mrs. Justice Marva McDonald-Bishop for her presence and her wisdom, and to each of you for joining us in this important exchange. And of course, I echo the sentiments expressed by the Vice Chancellor. Thank you.
Thank you, Dean Ali. Can we quickly, before inviting Professor Marvin Reed to speak, to just say happy birthday, Dean Ali. Happy birthday. We're pleased you're spending the evening with us. Can I invite Professor Marvin Reed to bring greetings on behalf of the Mona campus?
You can invite, but what I'll do is another matter. Let's see if we can adjust this. Hi, Brian, how are you doing? All right, colleagues, ladies and gentlemen, like Dean Ali before me, I wish to stand on the established protocols that were set forth by our chair, Professor Tracy Robinson. And before I get into my welcome, first let me apologize for the absence of our principal, PVC Williams, who unfortunately was not able to make it tonight because of a conflicting schedule. In fact, he and I were in Mobile this morning, and fortunately I told the policeman on my way down that I was here to meet Justice Sykes, so they let me through. Notwithstanding though, I've been said that I've been thrust in the proverbial hot seat, and looking around the room where I see a lot of you attired quite splendidly in black and so on, I'm reminded of the Jamaican proverb, which basically says, cockroach don't business and fall fight. And so why you say that? You see, I'm a medic, and I see all of these bright lawyer folks around. And our former DPP, Paula Lewin, said that when we have lawyers like this around, often the debate is hot. You know, so you'll be getting caught in the thrust and throw of the debate. And as a cockroach, I really don't want to be in there. I'll run in my little hole. But notwithstanding, my task here is to offer on behalf of the Mona campus, and more pointedly, the Faculty of Law, a warm welcome. Within a similar vein, I would like to extend a warm welcome to our keynote speaker, the Honorable Mrs. Justice Marva McDonald-Bishop, who will guide us through the underlying principles of sentencing, certainly within Jamaica, and because of the commonalities of the Caribbean jurisprudence, perhaps the Caribbean as well. Indeed, the subject of sentencing lies at the critical intersection of the rule of law, constitutional rights, and public safety, and represents a heartfelt wish of the common man when he or she utters the phrase, "We want justice." Thus, in a modern constitutional democracy like Jamaica, navigating this space is not simply about determining a term of imprisonment or even whether hanging should be resumed. It is a profound exercise in balancing the competing societal imperatives. It is ultimately a test of our commitment to equity, justice, and ethics. Moreover, the letter of invitation that I received from Dr. Blake included in a prefix to the substance of the lecture topic. That is, heavy is the crown. And as a young man who I believed was properly schooled in the Baptist faith by my grandma, and believe it or not, a member of your fraternity, a legal luminary by the name of, we call him Algie, Justice Algie Smith, who was my Sunday school teacher. My mind reflected on the two occasions that I can recall. I know there are a lot of members here from the Filippo Baptist Church, and so you may have more memories than me, but I can recall two occasions in which the crown was mentioned in the Bible. The first revolved around David's conquest of Rabbah, and thus represents a symbol of victory and conquest. As a former colony, our laws are still littered with the references to the crown, a reminder of the gravitational pull that as a society we still need to overcome. And as Bob said in his redemption song, none but ourselves can free our minds. The second occasion that I recall is the crown of thorns that was affixed to Jesus' head prior to his crucifixion. Clearly, the contrast here is not merely in weight, but also in symbolism, as a crown of thorns can be viewed as a symbol of servant leadership. And in the context of the discussion this evening, the principle of proportionate sentencing. Notwithstanding my reminiscence of my religious upbringing, for better or for worse, I would like to do a little promotion of the strategic directions of our Mona campus, and specifically focus on the mandate of my newly created office, which is to encourage, facilitate, and leverage the quadripartite groups of academia, private sector, civil society, and government to drive discussions, innovations, and solutions to societal problems. Indeed, this lecture series represents the raison d'etre of public universities. Within this context, the Mona Law Distinguished Lecture Series and similar colloquiums and workshops hosted by the University of the West Indies are really just vehicles to achieve this goal. So, ladies and gentlemen, I welcome you all again, and on your behalf, do look forward for an evening of a cerebral feast. Thank you.
Thank you very much, Professor Robinson. Can I invite now Dr. Celia Blake, our Associate Dean for Outreach and Continuing Legal Education, to introduce our distinguished lecturer. You may quickly discern that Dr. Blake and the President are classmates. Classmates from the class of 1994. And can I just ask before you join us, Dr. Blake, are there others here today? There we are. Special welcome to all the graduates of the class of 94 and the MonaMedia Law School class of 96, to which I can then join you, President. Please, Dr. Blake.
Thank you so much, Chair. Distinguished guests, ladies and gentlemen, it is a privilege for me to introduce our distinguished lecturer, the Honorable Mrs. Justice Marva McDonald-Bishop, OJ, CD, a daughter of St. Mary, whose early days were spent in the off-the-map village of Bamboo Walk. The young schoolgirl, Marva McDonald, outfitted in her immaculate white uniform, part of the Catholic tradition at Marymount High School, harbored no dreams of studying law. Her occupational ambitions shifted from teacher to nurse to bank teller, and perhaps lured by the apparent glamour of hotels as Jamaica's tourist industry gathered momentum in the 1980s, she even toyed with the idea of being a hotel receptionist. Subsequently, in sixth form at St. Mary High School, and no doubt captivated by A-level geography, she had a desire to become a meteorologist. As she prepared for A-level exams, the shocking, even if unwarranted detention by the police of a family member on suspicion of murder displaced her inclinations towards meteorology. A distraught Marva McDonald resolved then to become an attorney, and as if to signal the finality of this resolve, she proclaimed the decision to her grandparents, Neville and Christine McGee, her grandfather being assured that she had a good brain and was prepared to give his last mite in support of her educational endeavors. The resolve was met with personal setbacks initially, including financial hardship. But a glimmer of light appeared in 1986 when she left St. Mary to take up the post of Assistant Clerk of Courts at the Criminal Division of St. Andrew Resident Magistrates Court and later rose to Deputy Clerk of Courts. She tells a story, now cheerfully, of being shamed into pursuing her studies at the university, having been admonished as a time waster and as possessing no ambition by a well-meaning attorney, now King's Counsel. This reverse psychology worked, and Marva McDonald blazed her trail at the UWI in the humanities at Mona and then in law at Cave Hill. She left the UWI with the rare distinction of 2 consecutive first-class honors degrees and was dubbed prophetically as the phenomenal woman in the law faculty's yearbook, which marked the 25th anniversary of the faculty. Thereafter, she entered the Norman Manley Law School, and within a few short years of admission to the bar as part of the remarkable class of 1996, she began her judicial career at the Manchester Resident Magistrates Court in 2000. The rest is not only history, as they say, but also historic. We witnessed her swearing in as the first female president of the Court of Appeal of Jamaica on July 18, 2024. For all the history-making, though, she had no honeymoon. Earlier, in 2024, the Judicial Committee of the Privy Council, having quashed the convictions and set aside the sentences of the appellants in the so-called Vibes Cartel case, had remitted the case to the Court of Appeal to determine whether a retrial should be ordered. The Court of Appeal, by a panel presided by the then Justice of Appeal, McDonald-Bishop, had in June heard arguments and was due to hand down its decision shy of 2 weeks into her presidency on July 31, the eve of Emancipation Day, a mystic foreshadowing, perhaps, of the judicial outcome. The ears of all Jamaicans were cocked to their radios and electronic devices in tense anticipation of the words that were to come from the appeal court. Just after 2 o'clock in the afternoon that day, the barometer of national sentiment halfway tree in Kingston erupted in cheers. In a skillfully navigated, meticulously reasoned opinion of 70 pages, the newly minted Honorable President delivered an unchallengeable judgment, legally sound, sociologically sensitive, judiciously balanced, a must-read for law students, that resonated with the intuitive sense of justice of the bustling crowd of Halfway Tree and indeed many other ordinary Jamaicans. Only 7 months later, in Cecil Moore and the King, another legally important case signaled by the historic 9-member panel constituted to hear it, she led deliberations on the treatment of pre-sentence and pre-trial remand in the context of mandatory minimum sentences and in the context of a number of constitutional guarantees. No doubt, we will be further enlightened today about the friction arising as judges, long accustomed to being their own principals in the domain of sentencing, have had to plot routes through the minefield of mandatory sentences imposed by Parliament under the pressure of surges in serious crime, while having to keep in view the cornerstone principles of sentencing and balancing considerations of fairness to the parties involved. Her judicial aptitude and acuity have been recognized and sought after internationally. A temporary judge of the Grand Court of the Cayman Islands since 2011, she was also recently appointed president of the Commonwealth Secretariat Arbitral Tribunal, pursuant to the statute governing that tribunal. The tribunal adjudicates contractual disputes involving the Commonwealth Secretariat, including employment disputes not resolved by the Secretariat's internal grievance procedures. It is the first time that a Jamaican has acceded to the presidency of this international administrative tribunal. Her professional rising and achievements, outstanding and impressive as they are not, though, the measure of her person. Firm in a faith embedded in the Baptist tradition practiced at the Filippo Baptist Church in Spanish Town, which holds the memory of our enslaved ancestors, she envisions a model judicial system that not only serves Jamaicans of all walks of life efficiently and fairly, but which regards the dignity of its users, thereby honoring the toil of those ancestors represented in the chains interred in the very foundations of the Filippo Church. She's grounded in the values instilled in her during her Bamboo Walk upbringing: selflessness, service, strive for excellence, care of others, considerateness, compassion, cooperation, generosity, gratitude. And ever mindful of her own struggles and modest beginnings, she encourages and inspires as a lay preacher and a motivational speaker helping to nurture the minds of newer generations, particularly women. A member of the local and international associations of women judges, she's arguably the embodiment of the realization of the founding vision of the International Network of Women Judges to increase the number of women on the bench. But Justice McDonald-Bishop, while celebrating the strides of women in the judiciary, is wisely giving thought to the impact on the administration of justice of the current gender imbalance in favor of women in the Jamaican judiciary. Her writing in recognition of the inaugural International Day for Women Judges in 2022 is essentially a cautionary suggestion for our society and our policymakers to interrogate and address that reverse imbalance. She has not sacrificed family for profession. It may be fair to say that she has fused the two. Married to Keith, her best friend from the Faculty of Law class of 1994, and blessed with 3 children, today, all lawyers, her family is a close-knit unit of love and law, supported by her mom, Sybil. And my understanding is that another close family member is being minted for the profession right here at Mona Law. Today, in this lecture, she offers us insights from the vast wealth of her knowledge and experience. She is herself not unaccustomed to the teaching role, a long-standing associate tutor at the Norman Manley Law School, a frequently called-upon trainer at judicial education institutes and conferences, a presenter in various fora, unlocking the complexity of a wide range of intricate legal topics, and practice in rules and guidelines on sentencing. Ladies and gentlemen, please help me welcome our presenter of this evening's distinguished lecture, the phenomenal woman, hailing from St. Mary, from the Faculty of Law class of 94 and Norman Manley Law class of 96, from RM to the 13th President of the Court of Appeal of Jamaica, jurist par excellence, the first female President of the Court, the Honorable Mrs. Justice Marva McDonald-Bishop, OJ-CD. President, the floor is yours.
I'm left speechless by that deep introduction, which shows why my dear classmate, Dr. Blake, has a doctorate. She did her research thoroughly. I didn't tell her a thing about me. What she did was to bring up a synthesis of all the things she gathered about me. Thank you very much, Dr. Blake, for that touching and generous introduction. I felt almost special.
Sorry.
May I, Madam Chair, in the interest of time, adopt the protocol so ably established by you, and just to say a pleasant good afternoon to all distinguished ladies and gentlemen present here and online. I don't want to fall into problems identifying anybody here, but I will say a big shout out to the front row posse. That includes the leader of the opposition, who I did not expect to be here, State Minister Mrs. Marissa Dalrymple, and former President of the Court of Appeal, Mr. Patrick Brooks is online, but Justice Panton here, the troublemaker is here, Justice Hilary Phillips, and so many more. I'm so thrilled to see them, even KC Michael Hilton, who I didn't expect to be here, he not being a practitioner in the criminal courts. But of course, my dear Chief Justice, I don't want to start the protocol, but I can't overlook him. And those online, I must say to the president, the new president of the Caribbean Court of Justice, our own son of the soil, Justice Winston Anderson, and his judges, who I'm pleased to hear are online, Chief Justice Louis Blendman of Belize, my former colleague, Mr. Herbert Wells, Justice now in Barbados, the class of 1996, Norman Manley Law School, judges, lawyers, and all, members of the Court of Appeal, especially my colleagues who are here in great number, other members of the judiciary from the Supreme Court, Madam and Justice Andrea Thomas from the class of 96 is here. Everybody, I'm tired. My former students of the Norman Manley Law School, who I told today not to scout class to be here, principal, new principal, my husband and children, relatives, my friends all. Pardon me if I don't single you out. It's too long and I need time for my long presentation. I'm deeply honored and humbled by the invitation to deliver what the organizers have called a distinguished lecture here at Mona Law. Personally, I believe that that is a misnomer for what I see just as a little talk with you this evening. And I must apologize from the outset that if I fall short of any of your expectations, it's not my fault. Blame Dr. Blake. I also feel a deep sense of pride in sharing the stage with my two colleagues from the Norman Manley Law School class of 96, the chairperson, Professor Tracy Robinson, and you hear the big titles, and Dr. Celia Blake, who incidentally is also my classmate from Cave Hill. I'm very proud of their distinguished standing, along with another classmate, Ms. Hazel Jones, as esteemed faculty members of this noble institution. I thank them who insisted that I be here today. I thank the Vice Chancellor, Professor Hilary Beckles, whose books I could not stop reading as a history student. Professor Reed for his Baptist-led welcome. Madam Dean of the Faculty, Mrs. Shazida Halley, Professor Shazida Halley, with whom I shared a birth month. Happy birthday. All the members of the university administration and Mona Law who have extended a heartwarming welcome to me. It is indeed a special privilege to publicly share my thoughts and insights on a subject matter near and dear to my heart. And I'm excited to be part of the tradition of academic excellence at Mona Law, of which two of my three children and my youngest sister are the proud and fortunate beneficiaries. Please permit me, Madam Chair, before I go to my presentation, to say that I partly dedicate this presentation to two distinguished female jurists, former Chief Justice of Jamaica, the Honorable Mrs. Justice Zayla McCullough, retired, and the serving Chief Justice of Belize, the Honorable Madam Justice Louise Blenman, for selecting me to sit as a member of the Sentencing Guidelines Committee and Sentencing Guidelines Advisory Committee of Jamaica and Belize, respectively. It is this invaluable exposure and enriching experience, coupled with my practical background as a judge, that I suspect have brought me here this evening with this title of Distinguished Lecturer. Finally, I dedicate the lecture to the memory of two members of the Jamaican Judiciary's Sentencing Guidelines Committee who are no longer with us. The former president of the Court of Appeal and chair of the committee, the Honorable Justice C. Dennis Morrison, retired, who ably led us here in Jamaica on this initiative toward a structured sentencing framework. And of course, Attorney at Law, Ms. Nancy Anderson. I also pay tribute to the work, life, and memory of our fallen sister, colleague, and former classmate, Her Honor Ms. Ruth Lawrence, who recently passed under tragic circumstances. And incidentally, we share the same birthday, the 20th of October. We would each call each other on our birthdays. May the precious memories of my colleagues live on for eternity. My deepest gratitude is reserved for my most valuable senior judicial counsel, Mr. Jordan Jarrett, please stand, who who must assume his role as a co-presenter with me today, as he is fully responsible for creating the PowerPoint aspect of the presentation and has assisted with research, critique, and editorial services alongside AI, Yes Chief Justice, Co-Pilot, and Grammarly. So that's a long run-up, but I have to say it all. Pleasant good evening to you. Heavy is the crown, navigating sentencing within a constitutional democracy. Of course, I begin with the disclaimer that the views and opinions shared during this presentation are entirely my own. They do not represent and should not be regarded as representing the views or stance of the judiciary of Jamaica generally or the Court of Appeal in particular. Nor do they amount to a binding legal statement or an indication of any ruling on pending or future cases before the Court of Appeal. My comments are made solely for academic discussion with the aim of enhancing understanding of the complexities of sentencing and the challenges faced by the courts in this process. I want nobody to cite my own paper to me like a lawyer did before me in Manchester. I am not bound by anything I say here today. Thank you. No.
Charges made against the defendant. Parking on a double yellow line, my lord. Parking on a double yellow line. How do you plead? Not guilty, Your Honour. All the evidence before me suggests that you are guilty. And after giving this case due consideration, I shall find you guilty. And the sentence of the court upon you is that you be taken from this place to a lawful prison, and from thence to a place of execution. And that there, on a date appointed by the court, you be hanged by the neck until you are dead. And may the Lord have mercy upon your soul. It's only a parking offence, my lord. It's only a parking offence. It's a £2 fine. You will also pay the £2 fine.
No area in the administration of criminal justice provokes more interest, controversy, debate, anxiety, and even anger than sentencing. Sentencing, the act of determining the appropriate punishment for a convicted offender, marks a pivotal moment in criminal proceedings. It represents the intersection of crime and punishment, where justice must not only be done, but must also be seen to be done. While sentencing may be straightforward, applying the law to a convicted individual, simple. In reality, the process is much more complex and nuanced. Sentencing is not a mechanical task. It involves a careful balancing of competing and sometimes antagonistic interests, as each case presents its own unique circumstances, offenders, and victims. Additionally, sentencing decisions influence public perceptions of justice, affect the legitimacy of the legal system, and can either bolster or erode public trust in the judiciary and the wider state apparatus. Generally, too, sentences are required to be announced in public, making them a part of a judge's work that people notice and discuss most. As a result, judges not only have to follow the law when sentencing, but also must handle the psychological burden and pressure and stress that come from public expectations and reactions. Sentencing is therefore one of the most challenging and consequential tasks a judge undertakes. The timeless reflection of Judge Irving R. Kaufman, in his seminal article, Sentencing the Judge's Problem, written around 1960, captures the essence of sentencing as an extraordinary judicial burden, the weight of which is fittingly captured in the adage, "Heavy is the head that wears the crown." This is what Judge Kaufman said. If the hundreds of American judges who sit on criminal cases were polled as to what was the most trying facet of their jobs, the vast majority would almost certainly answer sentencing. In no other judicial function is the judge more alone. No other act of his carries greater potentialities for good or evil than the determination of how society will treat its transgressors. End of quote. Today's presentation, titled "Heavy is the Crown, Navigating Sentencing Within a Constitutional Democracy," aims to identify and examine the intricacies of the sentencing process, as well as some dilemmas and tensions faced by Jamaican judges, and judges, in fact, all over, in exercising their sentencing duties within the constitutional and legal framework that governs their role. Let it be clear, the phrase "heavy is the crown" bears no reference to the monarchy, nor does it touch upon debate surrounding Jamaica's constitutional status or the question of Jamaica becoming a republic. Instead, it symbolizes the judicial role itself, its authority, its symbolic significance in the administration of justice, and the heavy responsibility it entails. May I see the slide depicting the weight? The sentencing power, although often regarded as formidable and perhaps even enviable, also reveals the inherent vulnerabilities and human difficulties inherent in the judicial office. Judges must interpret and apply the law in accordance with the judicial oath they have taken, which is to uphold and defend the Constitution, to administer justice to all persons alike in accordance with the laws and usages of Jamaica, without fear or favor, affection, or ill will. The oath underscores the immense gravity of the judicial role. Heavy is the crown, even heavier is the head that wears it. By examining the challenges and complexities of judicial sentencing, this presentation primarily aims to enhance public awareness and understanding of the philosophy, principles, and processes that inform judicial decisions. It is believed, maybe stupidly so, that fostering a more informed, perhaps empathetic, and balanced public debate on one of the most significant aspects of criminal justice administration is not only crucial, but timely. Given the breadth of the topic, it would be impossible for me to do full justice to every aspect within the allotted time. Nevertheless, it is believed that an attempt is both necessary and worthwhile. The presentation is organized into 3 broad parts. Part 1, I call Setting the Stage. In Part 1, I look at the constitutional framework and the philosophical underpinnings that shape the sentencing process and outcomes. Part 2, the sentencing dilemmas, the practical and moral challenges judges frequently confront when exercising their sentencing discretion. And Part 3, some concluding remarks, including initiatives undertaken by the judiciary touching this aspect of the judicial role. Let me say that what I am presenting here this evening is a shortened version of the paper that I have. So I will not treat it as a formal document citing cases with citations and those formalities. The paper will be made available at a future date with proper footnoting and source referencing. So just to say that to properly examine sentencing within Jamaica's criminal justice system, it is essential first to outline the constitutional framework that shapes the process. This context not only clarifies the distinct roles of the executive, legislature, and judiciary, but should promote a better understanding of the complexities and tensions that arise as the three branches of government interact in the administration of criminal justice. A modern constitutional democracy is a system of government, and I stand to be corrected by Professor Tracy Robinson, in which power is divided among the three branches of state, the executive, legislature, and judiciary, and constrained by written or unwritten constitution. Jamaica is a modern, or so we say, a modern constitutional democracy. Now, certain features of this structure I will highlight that bear on the sentencing process. The rule of law, the separation of powers among the three branches, and the protection of the fundamental rights and freedoms of individuals. This government structure aims to balance power, ensure accountability, and safeguard citizens' rights. Although the separation of powers and judicial independence underpin Jamaica's constitutional order, all three organs of the state play a role in the punishment of offenders, each with its own distinct function. I detail the functions here, but in the interest of time, I'll just simply say that in essence, the legislature sets the statutory framework for the judiciary to apply to individual cases, and the executive enforces the resulting sentence. Through this structure of checks and balances, the Constitution seeks to ensure that no single branch dominates the process, and that sentencing remains anchored in fairness, justice, and accountability. The struggle to maintain this delicate balance is further complicated by evolving standards of justice, especially from human rights advocacy and adjudication. In Jamaica, the Constitution as the supreme law binds all branches of the state and guarantees that sentencing practices respect fundamental rights and freedoms as embodied in the Charter of Rights. Against this background, therefore, even those who have been convicted of crimes retain certain basic human rights. While some rights may be lawfully limited because of their status as offenders, others which are engaged during the sentencing process, such as the right to due process, the right to a fair trial within reasonable time, the right to respect for family life, and the right to protection from torture, inhuman or degrading punishment or treatment must always be observed. I will just look briefly at the traditional approach. Historically, sentencing was almost entirely discretionary. Judges exercised wide latitude in determining punishment, with no formal rules dictating the appropriate sentence. Each judge relied on personal judgment, experience, and philosophy. Sentences could be influenced by subjective factors such as public sentiment, social class, the color of one's skin, or the judge's personal outlook. Judicial independence was regarded as sacrosanct, and so any attempt to limit discretion was met with resistance. This broad discretion while intended to uphold independence, resulted in inconsistencies, disparities, and unfairness. The early philosophy of sentencing was mainly retributive, encapsulated in the principle, an eye for an eye. Over time, this shifted towards deterrence as societies began to focus on preventing future crimes rather than purely punishing offenders. The modern approach is that by the late 19th century, new ideas about rehabilitation began to shape sentencing policy. The development of parole systems and probation services marked a shift from punishing offenders to reforming them. Judges increasingly considered the offender as a whole person and not merely as the author of a criminal act, but as an individual shaped by personal history, social context, and potential for change. This marked the rise of individualized sentencing, where courts considered mitigating factors such as background, mental health, and social circumstances. 50 years ago, in the case of Cecil Gibson, Justice of Appeal Graham Perkins observed, and I quote, "It should never at any time be thought that a convicted person standing in a dock is no more than an abstraction. He is what he is because of his antecedents, and justice can only be done to him if proper and due regard is had to him as an individual, and a real attempt is made to deal with him with reference to the particular circumstances of his case. To ignore these is to ignore an essential consideration in the purpose of punishment, namely the rehabilitation of the offender." End of quote. This human-centered philosophy underscores that sentencing should not merely punish, but also restore and reintegrate. The ultimate goal is to reduce reoffending and promote safer communities. So, as justice systems matured and disparities in sentencing outcomes prompted calls for greater transparency and inconsistency, we see an evolving philosophy. Many jurisdictions began adopting structured sentencing frameworks or guidelines to support judicial decisions. In Jamaica, the first major step in this direction of a structured sentencing framework came with the landmark case of Misha Clement, where the Court of Appeal, under the pen of the then President Justice Morrison, laid down comprehensive guidance on a sentencing methodology. I was also a member of that panel with Justice Paulette Williams. Building on that foundation, in 2017, the sentencing guidelines for use in the Supreme Court and parish courts were formally promulgated under the auspices of the then Chief Justice, the Honorable Justice Zayla McCallum. Later, cases such as Daniel Rolston reinforced and refined these principles. Regionally, the CCJ Academy for Law, through its Needham's Point Declaration on Criminal Justice Reform of 2023, also emphasizes the importance of evidence-based, transparent, and proportional sentencing across the Caribbean. The declaration was endorsed by regional heads of judiciaries, including Jamaica's our own Chief Justice, Brian Stiles. Justice Anderson, the recently minted president of the CCJ, in a presentation entitled "Towards a New Sentencing Policy," presented at the first legal conference on criminal justice reform in Guyana in July 2024, pointed to the prominent place of sentencing in the Needham's Point Declaration. In summary, Justice Anderson noted that the declaration has incorporated numerous current ideas into a comprehensive package to assist courts in dispensing justice in sentencing. The recommendations include giving victims more voice in prosecution and sentencing, enacting and utilizing laws for victim restitution, using sentencing as a deterrent and rehabilitation tool, and establishing sentencing guidelines commissions to gather data and advise legislatures. Justice Anderson enumerated several components that he believes could go some way towards adoption of a modern sentencing policy. I invite you to read that paper. It's a wealth of knowledge on the subject. These modern sentencing frameworks seek to ensure that similar offenses receive similar treatment while still allowing flexibility to reflect the unique circumstances of each case. The balance lies in preserving judicial discretion while promoting proportionality, fairness, and equality before the law. Now, as it stands today, the sentencing philosophy dictates that judges must be mindful of the purposes of sentencing. There are 5 main ones, each reflecting a different facet of justice. Punishment and retribution, holding offenders accountable by imposing punishment that is just and proportionate. Deterrence, discouraging both the convicted offender, which is specific deterrence, and others in society, which is general, from committing similar crimes. Protection of the public or incapacitation, which is to safeguard society by removing the offenders from the community or restricting their activities. And there is rehabilitation and reform, which is to promote positive change in offenders by addressing the root causes of criminal behavior and providing opportunities for reintegration. Reparation and restitution, which is encouraging offenders to make amends by compensating victims or participating in restorative justice initiatives that acknowledge and address the harm caused. The key sentencing principles have also evolved, which I will only list in the interest of time. The paper will give you more details. Individualized sentencing, restraint, parity, which means similar offenses committed in comparable circumstances should receive similar sentences. Totality, when sentencing for multiple offenses, the combined sentence must not be unduly harsh or excessive. And above all, proportionality, which demands that the punishment match the crime. The punishment must match the crime, balancing restrictions on certain rights with the duty to treat offenders fairly and humanely. I close part 1 by saying, sentencing philosophy, policy, and practice have come a long way from the days of unstrained judicial discretion to a more principled, transparent, and balanced system guided by established policies, principles, and structured sentencing framework. Having set the constitutional and philosophical stage, we now turn to part 2, where the heavy weight of the judicial crown becomes most evident in the day-to-day dilemmas of sentencing, often in circumstances where no perfect answer exists. Paragraph 6 of the Sentencing Guidelines of Jamaica outlines the sentencing process, which closely mirrors the approach used in other jurisdictions. But despite the documented process, the sentencing procedure still faces challenges. For instance, judges may differ in their choice of a starting point for the same offense, since the starting point in each case must rely on the sentencing judge's independent assessment of what the particular case requires. Judges must also ensure there is no double counting when establishing the starting point and when considering aggravating and mitigating factors. Aggravating factors are those that increase the seriousness of the offense or the offender's culpability, while mitigating factors are those that lessen the seriousness of the offense or the culpability. Additionally, Judges may vary in how much weight they attribute to each aggravating or mitigating factor. They may also differ on the extent of the discount to be given for a guilty plea, or even differ on whether any discount should be given at all. So amidst all of this, the judge must also apply the relevant overarching principles and objectives of sentencing throughout this process. I will now focus on just a few common areas of the sentencing process which demonstrates the dilemma faced by judges. I will list them here. These include choices between non-custodial and custodial sentencing, balancing mandatory sentences imposed by Parliament with proportionality, selecting between life imprisonment and determinate sentences, particularly for murder, reductions for guilty plea, credit for time served on pre-trial remand, constitutional remedy for delay, consideration of the dependence of the offender, and the last being concurrent and consecutive sentences. Don't worry, I'll be finished. I think Dr. Blake told me I have 2 hours, but don't worry. I won't use that time. I will first look at custodial versus non-custodial sentences. Now, imprisonment is the backbone of most criminal justice systems, and there are typically strong public expectations for sentences of imprisonment in all cases, even where the law does not permit it. You see what came out in that little skit, where it was a parking ticket and the man was sentenced to hang on top of the fine. The first dilemma for a sentencing judge often arises in deciding whether to deprive an offender of his liberty by imposing a sentence of imprisonment, or whether the court should impose a non-custodial sentence like a fine, community service, or curfew. Determining whether imprisonment is warranted can therefore be contentious and lead to differences of opinion among judges themselves and among judges on the one hand, and the public, and not to mention the other branches of government on the other. In many cases where non-custodial offenses are imposed non-custodial sentences are imposed, judges are often seen as taken too soft or lenient an approach. Discourse frequently arising in cases involving motor vehicle manslaughter or causing death by dangerous driving, where fines are generally imposed. And we put on the slide there for you, a truck driver fined $400,000 for causing deaths of 2 people. We wouldn't want to show you the comments that accompany that article. Yeah, we have them, but we decided not to show them to inflame the audience. In such cases, public dissatisfaction can be considerable due to the perceived inadequacy of non-custodial sentences for serious harm. But we must note that the inclination towards non-custodial sentences is not a matter of judicial sympathy. Judges are duty-bound by statute to first have regard to non-custodial sentence options where those are available, having regard not only to the circumstances of the offense, but also the circumstances of the offender. The Criminal Justice Reform Act imposes a statutory mandate that in all cases where a non-custodial sentence is permitted as an option, it should be the court's first consideration. Imprisonment, therefore, should be reserved as a last resort and for the most serious of offenses. The language of the Criminal Justice Reform Act, however, still puts judges in the difficult position of deciding what to do in each individual case. In other words, judges continue to face the dilemma of determining which cases are the most serious or last resort. In fact, there's the case on the Privy Council with the death penalty, which is outside the scope of this paper. But they put in the judgment that you have to make sure this case is the worst of the worst. So in determining what is the worst of the worst, it's a serious problem for judges, because the legislation offers no clarification on what that means or what judges should consider. But what we do know, based on law, common sense, and a plain reading of the legislation, is that the court must be satisfied that a custodial sentence is the only suitable punishment given the circumstances of the offense and the offender. That is to say, the custody threshold must be met. To make these determinations, the court will thoroughly consider all circumstances addressing such factors as the harm caused or likely to be caused, the risk of serious future harm, the offender's age and maturity, the offender's criminal history, and general antecedents. However, even if the threshold is met, incarceration may still be avoided through personal mitigation or the suspension of a prison term that in Jamaica must not exceed 3 years. I now turn to the second aspect, is the mandatory sentences versus judicial discretion, my favorite part of the presentation. Thank you for being here, Minister. As sentencing philosophies developed towards fairness and proportionality, new challenges emerged. Concerns about inconsistent sentencing outcomes, the perceived excessive use of judicial discretion, and the imposition of lenient sentences have led legislatures across the Commonwealth, including Jamaica, to intervene more directly in the sentencing process. One of the most significant results of this intervention has been the introduction of mandatory sentences, including mandatory minimum sentencing, particularly in legislation addressing drugs, murder, and firearm offenses. These provisions were intended, they say, to achieve greater uniformity, project a firm stance against crime, and reassure the public that serious offenses would attract correspondingly serious penalties. In Jamaica, we continue to grapple with the issue of mandatory sentences. Leaving aside the arguments of constitutionality for now, other arguments and concerns arise in support of and against mandatory sentences.
New penalties for murder were passed in the House of Representatives yesterday. And so what was passed, and you have to really pay attention to this, there were amendments made to the Offences Against the Person Act, the Criminal Justice Administration Act, and the Child Care and Protection Act. These amendments represent a vital and deliberate response to the levels of violent crime in our society, particularly those involving the most heinous offense, which is murder.
In keeping with the terms and spirit of Minister Morris Dixon's comments, supporters of mandatory minimum penalties point to several advantages. Deterrence. They are believed to discourage criminal behavior by signaling that certain offenses will be met with severe consequences. They say they promote predictability and uniformity in sentencing, reducing perceived disparities between offenders. And the proponents also say that longer sentences keep dangerous offenders off the streets for extended periods, which may reduce crime and enhance community safety. On the other hand, there are strong arguments against the continued deployment of mandatory minimum sentences.
That means that one court is going to be faced with a situation in which, unless the plea bargaining system can become very actively used, which it has not so far, we're going to have a much higher percentage of cases going to trial than are disposed of through guilty pleas and so on. Because the inducement to plead guilty will not be there when you're staring at a mandatory minimum sentence, which is a significant period of time.
Thank you. As the leader of the opposition did, many commentators point to the disadvantages of the mandatory minimum sentences, which they contend outweigh the benefits. Among the disadvantages are lack of flexibility. Judges lose the ability to tailor sentences to individual circumstances, motives, or levels of participation. Disproportionate outcomes, it means they can lead to excessively severe or contrary to basic principles of justice. Increased backlogs, because with little incentive to plead guilty, more accused persons may opt for a trial, resulting in prolonged case resolution and increase in costs. Weakened rehabilitation. Extended incarceration may harden rather than reform offenders, leading to higher reoffending rates after release. Economic burden. Longer prison terms increase correctional and administrative expenses. And limited alternatives. Probation, community service, and other restorative options are often unavailable, even for low-risk offenders, rendering mandatory minimum sentences less effective at reintegrating offenders into society and repairing the damage their crimes cause to the society. The constitutional issues are there. The constitutionality of mandatory minimum sentences or mandatory sentences has been the subject of much judicial discussion. The major concern for the court was whether mandatory sentences breach the separation of powers doctrine by transferring the judge's sentencing discretion away from the judicial arm of government and placing it in the hands of the legislature. This shift can generate tension between the legislative and judicial branches, raising constitutional concerns about separation of powers and the proper limits of parliamentary authority in matters of sentencing. Former American Chief Justice Earl Warren in United States and Brown referred to the transfer of power away from the judiciary as trial by legislature. Moreover, these provisions offer conflict with established principles such as proportionality and individualized sentencing. Now, the constitutionality of mandatory sentences was notably considered in the landmark case of Hines and the Queen, which was an appeal from Jamaica. Broadly speaking, the Privy Council established several principles that have stood the test of time. Firstly, it says that the sentencing of offenders is one of the core functions of the judiciary, which Parliament cannot transfer out of the hands of the judiciary or unduly restrict. Any such transfer or undue restriction by placing the power, for example, to determine the length of sentences in individual cases in the hands of non-judges or the Governor General constitutes a violation of the separation of powers. Secondly, it held that mandatory sentencing provisions are not of themselves unconstitutional unless they seek to eliminate the role of the judiciary in prescribing the penalty to be served in individual cases. However, if a mandatory sentence applies to all offenders across the board, it is not unconstitutional. Recently, in J. Chandler against the state of Trinidad and Tobago, the Privy Council examined whether the mandatory death penalty violated the separation of powers under the 1976 Constitution. The board found the separation of powers is not a standalone principle separate from the Constitution or above it. It is within Parliament's authority to legislate penalties for offenses and the mandatory death penalty does not breach this principle unless it targets specific individuals, which would be unconstitutionally unacceptable. Affirming its decisions in Matthew and Lendor, the board unanimously agreed that mandatory penalties set by legislation do not violate separation of powers, provided they are not otherwise unconstitutional. The European Court of Human Rights has also upheld a legislature's right to impose mandatory sentences to the extent that they leave room for individual assessment and potential release by provision of a minimum term and eligibility for parole. I've also looked at the CCJ's position, and although the CCJ and the Privy Council did not agree on one aspect regarding the death penalty as it relates to the savings law clauses, but both courts accept that mandatory sentences are not ipso facto unconstitutional. The approach of the Privy Council in Tafari Morrison and the CCJ in Seninga against the Attorney General of Belize are instructive in this regard. So both apex courts appear to agree that mandatory sentencing provisions operate only as a normative starting point for the sentencing exercise and are not absolute fetter on the court's discretion in sentencing. Both courts find support for this approach in the constitutional guarantees for fundamental rights and freedoms. So what this means then is that although Parliament is entitled to create mandatory sentencing regimes, the court's duty to do justice in accordance with the Constitution is superior and may require departing from Parliament's prescription in individual cases. Many cases demonstrate this. I will highlight Tafari Morrison, a judgment that was written by Justice Phillips, who is here, and Zuninga against the Attorney General. The Privy Council and the CCJ affirmed that a sentencing court is not required to impose a mandatory sentence, where to do so would be grossly disproportionate and amount to inhumane punishment in violation of the Constitution. The Supreme Court of Canada reached a similar conclusion in the celebrated case of the Queen against Smith, in which the Canadian Supreme Court held that a minimum sentence of 7 years for importing narcotics in the circumstances of that case constituted cruel and unusual punishment and therefore contravened the Canadian Charter of Rights and Freedoms. So I end this part by saying, while legislative direction and prescribing of mandatory sentences are legitimate, and mandatory sentences clearly serve important purposes, they cannot override the judiciary's duty to ensure individualized and fair outcomes that comply with the Constitution. In Jamaica, Section 13 of the Charter doubles down on this responsibility by expressly binding the organs of the state and all public authorities to exercise their functions in an equitable and humane manner. Maurice Tomlinson, and TVJ, et al., Dale Virgo, the Board of Management. So, when you get the paper, you'll see more on that. I'll now proceed to the third aspect, life imprisonment against determinate sentences. Apart from the death sentence, which is outside the scope of this presentation, a sentence of life imprisonment is the most restrictive on the life and liberty of a convicted person allowed within the criminal justice system. It is understood that where Parliament has set the sentence of life imprisonment, that this signals that the offense is the most serious and reprehensible. The most prominent is murder. Sentences of life imprisonment are also prescribed for other offenses like rape and incest and so on. And most recently, for illegal possession of firearm or ammunition in terms of what was interpreted to be a mandatory penalty of life. In this context, focus will be on the offense of non-capital murder, for which life is discretionary. The law does not permit judges to reflexively sentence individuals charged for non-capital murder to life imprisonment, where a determinate sentence is an option, simply because Parliament stipulates that an offense may attract a sentence of life. One misconception about the sentence of life imprisonment is that it requires, in all cases, that a convicted person is to remain in custody for the rest of their natural life. That is not so. Jamaican law and the laws across the Caribbean either establish in legislation or require the courts to stipulate a period after which the convicted person can be deemed eligible to be considered by the parole board for release into the public. So a person who the parole board deems fit may be granted parole and released from custody back into society after serving a minimum term. In fact, I was led to find out the other day that even when the court says a minimum term, parole, the prison authorities release the people on what they call remission. So at the end of the day, it seems to suggest that the executive comes up at the back, in the back, and reduce the sentences imposed by the judiciary. But that is for another day when I'm invited back to give a lecture. A sentence of life imprisonment therefore really means that the convicted person will be subjected to the jurisdiction of the state for the remainder of their natural life. So they will be supervised by correctional service personnel. They do not spend the rest of their lives in prison in the Jamaican context because we do not have something that says life without parole, at least not yet. So, if they are given life imprisonment, released on parole, they are liable to be taken back into custody if they fail to abide by their parole conditions. I will invite everyone who has time to look at the case of Roland Brunstaff against the King, where judicial guidance has been given by the Court of Appeal with particular reference to the Eastern Caribbean Supreme Court sentencing guidelines, which we viewed as very helpful in determining when a judge can give a determinate sentence rather than life imprisonment. The crucial and overarching question to be considered is whether the gravity or serious nature of the offense which was committed or the dangerousness of the offender warrants placing the offender under the jurisdiction of the state for the remainder of his life through the imposition of a life sentence. The Attorney General's number 32 and the King against Chapman. If the seriousness of the offense and the dangerousness do not signal a need to protect the public through judicial supervision of the convicted person for the rest of their natural life, a life sentence is not warranted. We notice Parliament, as you would have heard, pass laws saying life or with 50 years before parole in some instance and 40 years before parole in another instance. Those are all subjects for me to come back to talk about in the next 10 years. Thank you. It's just like one of my judgments. Sorry, law students. I now turn to a fourth area, reduction for guilty pleas. Sentence reductions for guilty pleas have sparked significant debate and strong disdain from the public. Professor Reed, we have the comments in relation to a case, but we will not show it either, but we have them. The public outcry was most recently pronounced in the case of Kwesi Hart against the King, the case involving the senseless fatal stabbing of a student of Jamaica College on a public bus because of a dispute over a cellular phone. The Court of Appeal explained that the sentencing judge, while taking into account the appellant's guilty plea, failed to apply the reduction as required by law. And I think this is what prompted Parliament to go back and raise the deeming provision of life sentence from 30 to 50 years now, I think. So they have responded to the Court of Appeals reduction on account of a guilty plea. But with all that, public debate ensued. It is a long-standing principle of the common law that a sentencing judge should grant a reduction in sentence for a guilty plea unless it is against the interests of justice to do so. This principle encourages early admissions of guilt, thereby saving court resources, reducing victim trauma from reliving the crime in court, fostering cooperation with the justice system, and promoting its efficiency. The requirement to give sentence reductions for guilty pleas is now codified in the Criminal Justice Administration Act. So Parliament has stepped in this area. In that act, Parliament has permitted a reduction for a guilty plea in prescribed circumstances, allowing for sentence reductions based on factors such as the timing of the plea and the circumstances of the offense. Some offenses, of course, are excluded by the Act. The dilemma persists, however, because judges must decide whether the circumstances of each case warrant overriding all the benefits recognized by law as arising from a guilty plea. The judge will often question whether the plea shows genuine remorse or simply responds pragmatically to strong evidence. This does not mean it is impossible for the court not to give a reduction. In Lincoln Hall and the King, a decision upheld on appeal, the sentencing judge had declined to give the appellant a discount due to his long history of offending. That decision was upheld on appeal. More recently, in the case of Jason Gray, the court refused to overturn a trial judge's decision not to grant a reduction for a guilty plea in relation to the double murder of 2 children, because in the sentencing judge's view, a reduction would have shocked the public conscience. So the court has the flexibility in terms of how it treats with the statutory provision regarding reduction for a guilty plea. But as I said before, even within that framework, judges differ, as doctors differ, and patients die. The fifth area, and I'm almost there, is credit for pre-sentence detention. Would you believe I've left out many areas? Yes, I have. But Dr. Blake said I must come here to give a distinguished lecture, and I'm doing it. Another challenge faced by the Jamaican judiciary was determining whether and how to fully recognize any time a convicted person spent in custody prior to sentencing. This is an area where Parliament has not yet intervened, but I suspect soon. Therefore, the recognition for time spent on pre-trial remand is a judicial construct established primarily by the Privy Council's decision in Kalachand and another, a case from Mauritius, and the CCJ's decision in Romeo da Costa Hall and the state. The principle was adopted in Jamaican jurisprudence through Richard Brown against the Queen. I think Justice Frank wrote this one, Williams wrote this, and Misha Clement. Since those decisions, the time spent in pre-sentence custody is now recorded and deducted through simple arithmetic, as you can see on the chartboard depicted, effectively resulting in a reduced sentence. The primary reason courts credit time spent in custody before sentence is simple. As the Privy Council said, it is a basic right to liberty. If that time is disregarded, the total period a person remains in state custody from arrest to release becomes longer than the sentence imposed by the judge. In essence, they would lose their liberty for a duration exceeding what the court deemed appropriate for the offense. The Privy Council said in Kalachan that recognizing and giving credit for time spent is a matter of the basic right to liberty, which is enshrined in our Constitution. The difficulty, however, in granting the discount often arises when the sentence imposed is a statutory mandatory minimum. This question has challenged the Court of Appeal because the question is whether credit could be given for pre-sentence remand below the mandatory minimum to account for time served. For a time, the Jamaican Court of Appeal held that it was impermissible for sentencing judges to do so, and that only the Court of Appeal could grant credit in circumstances if a sentencing judge issued a written or oral certificate pursuant to Section 42K of the Criminal Justice Administration Act stating that the sentence is disproportionate. The case is Erwin Ariot against the King. But as you have heard, the doctor who conducted her research in Sessamore against the King in 2005, a 9-member bench ruled that the appellant should receive credit because we had to revisit her earlier decision for nearly 3 years spent on trial remand prior to his retrial and sentence, despite the statutory minimum. The appellant had spent almost 3 years in prison following a conviction that was subsequently quashed and the sentence set aside. Upon his retrial, he was not credited with what some judges would call the dead time that he would have spent as a consequence of the first trial. The Court of Appeal concluded that failing to credit pre-trial detention in the presence of a mandatory minimum could be manifestly unfair and unjust, thereby infringing an offender's fundamental right to liberty, basic right to liberty guaranteed by the Constitution. This marks a departure from the court's previously hardline stance in Erwin Ariot and his progenies, reflecting a commitment to ensuring not only that sentences correspond to the crimes committed, but also that the sentencing decisions and their implementation respect the constitutional rights of convicted individuals. I personally believe we deserve a clap, and I ask the Court of Appeal judges to clap themselves. Mr. Hilton, I see why you're here today. You have to clap us. The sixth area, constitutional remedy for delay. And this is a significant challenge in Jamaica. Our justice system, the delay is chronic, and this has affected the progress of cases in criminal proceedings, both at the trial and appellate levels. A pressing problem that challenges us at the Court of Appeal is the delay in transmitting transcripts from the court below for appeals to be heard, but there is an improvement in this area now. This often takes years and brings the judicial system into direct conflict with the constitutional rights of a convicted person to have his conviction and sentence reviewed by the Court of Appeal, a superior court within a reasonable time protected by Section 16 of the Charter. Over the time, the Court of Appeal, following other cases such as Melanie Tappan, Director of Public Prosecutions, Attorney General's reference number 2, and Bulel against the state, have applied or deployed the mechanism to reduce sentences as a remedy for a constitutional breach of the right to a fair trial within a reasonable time. We are sure that this will cause the public, of course, to be outraged from time to time, because the public's expectation of justice to be meted out will not really materialize, given the fact that we have to pay regard to the constitutional rights of the appellants or the convicts. So there are many cases, too numerous to mention, where a reduction in sentence has been granted for inordinate delay. And these cases in which a remedy by way of a reduction in sentence has been given serve to highlight how constitutional norms can directly shape sentencing outcomes and how judges must balance individual rights against societal interests in the administration of justice. In the case of Evan, Jack, and the King, against the King, the court actually quashed the conviction, means that this appellant did not face, although he was in custody before, but he did not face imprisonment as a sanction because of the inordinate delay that the court found would have caused an injustice to him because portions of the transcript were missing at the time. But these types of cases may spark public outcry, as victims may be left without the satisfaction of having the case tried, hearing a lengthy sentence pronounced, or the offender punished. The recently retired Director of Public Prosecutions, Ms. Paula Llewellyn, King's Counsel, described this as a looming unfairness, I can't say it like her, caused by the system's failure to ensure that trials and appeals are conducted within a reasonable time frame. The penultimate area of dilemma now is considering the offender's family circumstances. Look at that picture. An area which has not been extensively explored in Jamaican jurisprudence is the duty of judges to take into account the collateral consequences of a sentence on an offender's family and dependents. Placing any primacy on an offender's family life is often a hard nut to swallow for the victims of crime and the public. It is challenging to consider the offender's children and familial circumstances when they would have failed to do so when committing the criminal offense. At least, that had been the long-standing view among judges, myself included. But modern sentencing philosophy has directed otherwise. It is now widely accepted in sentencing jurisprudence in several jurisdictions that the care of children and other dependents of an offender is a relevant consideration when mitigating a sentence, particularly in the case of the offending mothers or the sole caregivers. Z.H. Tanzania and the Secretary of State, and the case of the King against Petherick from the United Kingdom. And I had to apply this principle in a case in the Cayman Islands in respect of a female offender with a child in special need. She did not get much anyway. She got 20. I sentenced her to 12 years, but I took 6 months off for a special needs child. Court of Appeal did not trouble that. This consideration, it is said, recognizes the offender's constitutional right to respect for family life guaranteed by Article 8 of the European Convention on Human Rights, which is analogous to Section 13.3J2 of our Charter. Support for this approach is also to be found in international conventions, which I have named here, but I won't say it now in the interest of time. The need to have regard to the offender's family life adds another layer of complexity to sentencing that judges must navigate in the interests of justice. The law calls upon courts to ensure that their judicial discretion in sentencing parents is not exercised in isolation. The courts must balance the interests of justice with compassion, recognizing that the ripple effects of a custodial sentence extend well beyond the individual accused. The gravity of removing a child from parental care demands strong justification and careful consideration of alternative sanctions. The court is required to balance the interests of the offender's family against society's interest in the proper enforcement of criminal law, the criminal law having regard to the seriousness of the offending. The law, however, does not require the courts to treat the offender's family circumstances as a trump card capable of overriding the need to sufficiently punish serious offenses. The decision of the Court of Appeal in Kimani McDermott against the King, written by Justice Dunbar Green, demonstrates a delicate balancing exercise that must be done. In that case, the court accepted that a trial judge was entitled to take account of an offender's role as the sole breadwinner for his family, but that the serious circumstances of the offense outweighed this. As this era develops in Jamaica's jurisprudence, our courts must therefore carefully balance competing factors. Finally, concurrent versus consecutive sentencing. Where there is more than one sentence in play, judges must determine whether the sentences should run concurrently, which is at the same time, or consecutively, one after another. This decision significantly impacts the total period of imprisonment to be served by a convicted person and will determine, for example, in a case where two 20-year sentences are imposed, whether the convicted person will serve 20 years in the event the sentences are to run concurrently, or 40 years in the event they are to run consecutively. The public often calls for consecutive sentences, sharing the view that consecutive sentences appropriately remonstrate serial offenders.
I hereby sentence you to 2,500 consecutive life sentences plus 1,000 years. Once you pass away, you will receive an attempted escape charge with an additional 200 years being added to your sentence, which you will begin serving in the afterlife once you get to hell. Should you be reincarnated after your death and return to Earth as another person, you will be arrested at birth and you will spend your entire next life in the state penitentiary.
Unbeknownst to the public, there are two challenges to this approach. Firstly, the common law limits us to ordering consecutive sentences only in specific circumstances, such as when the offenses were committed on separate occasions or while the offender was on bail for other offenses that he eventually was convicted of. Secondly, even if the common law or parliament expressly permits or requires the court to impose a consecutive sentence in a particular case, the Constitution, which judges are sworn to uphold, especially sections 13.3.0 and 13.6, mandates that the courts, when doing so, must ensure the punishment is not grossly disproportionate and does not amount to cruel and inhuman punishment or treatment. Therefore, we are bound by our supreme law to administer justice based on the circumstances of the case, considering the nature and severity of the offending. The ultimate responsibility is not merely to follow a sense of what you think a person deserves, but to arrive at a proportionate sentence that reflects the overall seriousness of the offender's conduct, the offender's peculiar circumstances, and is constitutionally valid. Part 3 of my lecture. Read a sigh of relief. Sentencing is and will remain one of the most challenging and closely scrutinized responsibilities faced by members of the judiciary. It exists where law, and you'd have heard Professor Reed says it in the Baptist style, where law, morality, and humanity converge, requiring judges to balance legal principles with a deep understanding of human circumstances. While the public's attention often centers on the outcome, such as the length of the sentence, the headlines, and the associated emotions, there's much more to sentencing than simply the result. As discussed, the process is not just about the final decision, but involves careful reasoning within constitutional boundaries, placing a heavy responsibility on the judiciary to ensure justice is both done and seen to be done. In concluding, I would like to emphasize that some challenges inherent in judicial decision-making can never be fully eradicated. The necessity to make difficult choices will continue, and there will be occasions when judges do not reach the perfect solution in every case. The public may not always, or perhaps ever, agree with our decisions. And much of this disconnect between the judiciary and the public will remain unresolved. Nonetheless, judges must diligently honor their judicial oath, applying the law impartially and without fear of contradiction or repercussions. Judges must also be unafraid to extend the reach of the law as far as the law allows, so that the serious consequences of criminal behavior are strongly felt by those who commit criminal acts. The burden borne by judges in the dispensation of criminal justice is immense. The metaphorical crown is heavy, and the challenges confronting the judiciary are substantial. Nevertheless, there is a steadfast commitment to mitigating these dilemmas to the best of our abilities in pursuit of justice and the public good. I think my judges would agree that I can speak for them right here. In this complex environment of a modern constitutional democracy, a consistent commitment to the proper administration of justice and reform will ensure that justice is not only done, but also seen to be done by the judges responsible for punishing society's transgressions. May God help us all in this noble endeavor. I thank you.
Thank you very much, Madam President. Yours was a majestic tour of the area of sentencing and well appreciated by us all. Can I invite a final year student, a direct entrant, and if I'm reminded you were a direct entrant in the LLB program, Noel Nichols from the Bahamas, to present a token of our appreciation to you. President?
Good evening, all. Protocol being established. Madam President, on behalf of the Faculty of Law and the students in particular, we want to extend our thanks for your presentation. Indeed, it was a distinguished lecture. Many of us have sat in class with Ms. Pusey in criminal law and Prof. Robinson in constitutional law, debating some of these very things and reading the words of your judgments and the others here. And for you to bring it to life and to share your practical experience is a real treat and a privilege for all of us. So thank you so much for this presentation, and please accept this token of our appreciation for your participation tonight. Thank you.
So in closing this evening's proceedings, I want to thank you again, Justice McDonald-Bishop, for being here for the lecture, and also to thank you for your leadership, your jurisprudential leadership, your administrative leadership. But I also want to say, particularly with the presence of the Chief Justice here today, that we thank you both for bringing the courts to the people of Jamaica. I think in my class, when the hearing of Cecil Moore was live, we simply turned it on the screen and watched. We couldn't do it for the entire 2 hours, but we also did it while the Chief Justice was sitting in an important criminal case. Never before in the history of legal education have we had that possibility. But these kinds of conversations with us, which are conversations with a wider public, the ways in which you have engaged ordinary Jamaicans through your ideas and your aspirations for the justice system are well received and highly valued by us, and certainly very important to us as legal educators. I also wanted, President, to just say we're appreciative of who you are, your kindness, your empathy, and also the ethic of care which you practice and you also preach. I want to offer thanks more generally to the team that worked on today's lecture, all the administrative staff, and you can tell that for Dr. Celia Blake, this was the most important of tasks, to have the lecture and for us to hear from President McDonald-Bishop. And so I want to thank Dr. Blake, I want to thank all those who worked on the lecture today. I also want to thank the MonaMedia team that are streaming and are indispensable to our ability as educators to have a public face, for our classrooms to be spaces where others can participate through streamed proceedings, and our appreciation and debt to you remains at MonaMedia. I want to thank the students who took you into the room and will take you out to refreshments or ushers. We're happy to be in a room well represented by our students, but also that you have participated in today's activities. And then, of course, to all of you who are here, our deep appreciation for joining us in person, joining us virtually from all over the Caribbean. Many thanks to you all, and please join us as we have a drink and have something to eat outside the room. Thanks, everyone. Good night.